I think we should start, right?
Yeah, this session is on privacy.
Privacy, data protection.
Okay, privacy data protection.
É muito.
These are parallel sessions. So here, this is privacy and data protection, and downstairs we have robots and autonomous vehicles. So
If there's anybody who wants to go downstairs,
but we have some robots here. So
Okay.
Okay, good morning, everyone. We're going to start the session. I'm not going to introduce the authors of the papers. I'm going to introduce the speakers.
Good point. I'll introduce the speakers in the order that I have them here, unless you have a preferred order yourself. You're sitting here. Do you want to start? Or do you want to start? I have Alexandra as a starter, but as you're sitting here. Yeah? Okay. Oh, you're already sitting in the right order.
Yeah.
Okay.
This is reserved for you.
No. I'll be sitting here, otherwise I can't hear and see you.
Should you please share and so you can have like more space?
Welcome. I'm filling in for Ronald Leenes, who very unfortunately could not be here, so I'll be chairing the panel on his behalf. And I have his written comments on all your papers, and I will provide them after the session, as we discussed, to have some room for discussion, as we have a very tight schedule already with 5 presenters of you. Alexandra, you are a postdoctoral researcher at the Blockchain and Society Policy Lab at the Institute for Information Law, IViR. I did my master's there. Say hi, at the University of Amsterdam in the Netherlands. You are an associate professor, associate researcher, sorry, at the Institute for Communication Science in Paris as well. Within the research group Information and Commons Governance, and you've worked as a research fellow at Humboldt Institute for Internet Society in Berlin. You've been around. You hold a PhD in law from the Center of Legal and Economic Studies of Multimedia at the University of Paris. Paris 2, Pensionassas. Okay. I'll leave it to you.
Okay, so this, I suppose. Yes, okay. Hi, can you see the slides? Okay, great. So this presentation, hello, good morning. Thank you for being here in this session today. So this presentation I'm going to do is not related to my current affiliation, so it's not going to be about anything remotely related to the blockchain, but it's it came to be due to my previous research at the Humboldt Institute for Internet Society. I was researching machine-generated non-personal data, and obviously the question of distinguishing non-personal and personal data came up, and of course the question of consent in anything that has to do with algorithmic processing, from artificial intelligence to machine learning processes of personal data. So first of all, the European Commission has recognized the value that comes from reaping the potential of algorithmic processing of personal data, and it has been at the forefront of the Commission's digital single market agenda. So it's recognized as a key source for innovation and growth, because the main goal of all algorithmic processes is to re-engineer current power structures and for the greater societal good. However, the data protection issues have been very much an issue in regulating the free flow of data in the European digital single market. And whenever we talk about data protection, whether it be from the US perspective or from the European perspective, we talk about control over personal data, increased individual autonomy over this data. So from the concept of privacy self-management that the US scholars would talk about, we would talk about more about providing processes that would give people control over their personal data and means to weigh the cost and the benefits of how the data are being processed. And at the same time, the GDPR talks about giving natural persons the control over their personal data and in the context of the autonomy that they should have. So whenever we talk about the social need of having control over their data, we talk about, obviously, agency. And agency is going to be translated in legal terms in consent, which is the first tool and the most important safeguard that's considered in the GDPR for any enhanced data control system. This is obviously not a new issue. Consent has been like the main tool for data protection regulations. We're talking about informed consent at the Data Protection Directive of 1995. The GDPR has come and it has enhanced and given more details on what consent would imply. So we talk about freely given, specific, informed, unambiguous indication of the wishes of the data subject. And those are obviously terms that are being interpreted by the Article 29 Working Party. They had given, which is the European Data Protection Officer, and they have given official opinions about what it means to give an informed consent, what it means to give an express consent. Both in 2011, a very extensive opinion about the concept of consent, and in 2018, a more specific one related to the Internet of Things and algorithmic processes in general. So the need to re-establish what consent means in the context of algorithmic processing has been reiterated by multiple actors, by civil society, by organizations, and also by the Article 29 Working Party. So AI pushes the limits of this of the consent in traditional data protection mechanism, because what we mean traditionally by consent, it requires a specific notification of the data processes, the data collection, the data processing, also the purposes of the processing, the duration, specific limitations, and adequate notice and ex-ante knowledge of what the purpose of this collection and processing will be. This poses very important issues when it comes to adapting these two concepts, because from the technical point of view, both machine learning and artificial intelligence have as a functionality, as an essential functionality of their design, the fact that we cannot really specify or explain what happens or how the processing happens. So what is the problem technically in how we provide consent, how we ask for consent? It has become progressively harder to implement mechanisms of continuous consent during the processes, and also implement mechanisms to give the data subjects a way to retract their consent from the data processing, but also they have become, it's increasingly hard to create mechanisms that implement those theoretical underpinnings of, moral underpinnings of consent. So how do we represent individual autonomy, how do we represent self-determination into the processes that we build? So we have arrived at the conclusion that informed consent is very hard to implement in the way that we perceive it today, and that means that if we continue to insist in the way that we perceive consent right now, this means that it will eventually erode the actual concept of consent. It will be reduced to simply a simple formality that is derived and deprived of any meaning. And this is not only an academic discourse, it's not something that scholars are worried about, but it is also something that the Article 29 Working Party has acknowledged recently in their opinion regarding the Internet of Things when they talk about low quality consent. So this is something that is an actual problem that needs to be addressed. At the same time, there needs to be a balance between data protection and artificial intelligence and all emerging technologies, because we also, at the same time, by protecting the social value of data protection and consent, we also do not want to sacrifice core values of what the technology is promising to deliver. So by ways to, by overprotecting data protection and by sticking to a very strict literal application of consent, we may end up stifling the technology that we are seeking to develop, and that is something that goes against what the agenda of the European Union is about. So, for example, another example is, so we know the text and data mining exception that has been recently implemented in the Copyright Reform Directive. We have a lot of talks about how we're going to promote the free flow of machine-generated data in the European Commission. So this is something that is seriously being thought about in the context of the regulators in the European Union. And not only giving a lot of weight in data protection, that is. So admitting that consent, giving consent in the digital environment in algorithmic processes has a lot of problems. There has been a lot of technical solutions that are being applied or being proposed. So we had during the evolution of digital consent, we have the creation of better privacy notices, better end user license agreements that make it more easy for the reader to understand the context of the processing. We have the proposal of a lot of pictograms in the sense of Creative Commons licenses, but for privacy regulation. And then we have also proposals that go beyond those. Those really, the pictograms, for example, have not really taken off in a more transnational way for multiple reasons. We also have the proposal to integrate some visceral notices to make the user experience what the issue is when it comes to consenting to some personal data processing. And we also have the proposals of creating artificial intelligence privacy enhancing helpers to basically reverse the technology to the benefit of the data subjects. So those are mostly technical solutions on how we take an already solid concept and adapt it to the algorithmic processing context. But we also have some conceptual reform solutions. So taking it, for example, from the contextual integrity theory that Helen Nissenbaum was explaining yesterday. We also adapting it to a more artificial intelligence and machine learning environment. We admit that by sticking only to consent is not enough, but we should adapt it to the contextual approach of the use. Of the purpose and the use of the processing in order to not negate what consent is about, but actually to end up empowering the individual autonomy of the data subject. However, there are also other sides of paternalistic approaches that say that since consent does not work, then we should abandon the concept altogether. We should look for other ways, or we should, data protection does not work as it is, and so we should find a completely different system. And there are more limited solutions to this approaches. So there are some scholars that propose fair uses of data protection. So basically admit that some uses should not require consent or should not be under the data protection regulation, or in the context of the GDPR, saying that we should expand other legal processing grounds, such as, for example, the legitimate interest of the data controller. And so go more towards expand more the concept of legitimate interest and not be founded so much on consent when it comes to artificial intelligence. This is not about limiting data protection. but the reconciliations that need to happen between data protection and AI have two problems. First of all, it's the broad scope of application of data protection regulation, and on the other hand, it's the friction between what the GDPR is about, that's a more centralized and more deterministic rationale of how the data processing works, and the context of algorithmic processing technologies. So, for example, we have a scholar that recently qualified the GDPR as the law of everything, saying that in a context where all processes in a data-driven society where we develop technologies to recognize patterns, profiling, make predictions, then every data-driven society will be determined by the GDPR, and this is basically a very big problem. What are the solutions that are being proposed is basically to not limit data protection, so to not go against what data protection is about, but to create a more modular approach to the enforcement of rights according to the intensity, according to the processing scenario, and so limit how the enforcement and the intensity of the enforcement is going to be, or look closer to what the technology is about and assess the cost and benefits of identifying a data subject, and so enforce the rights accordingly. So this is not about diminishing data protection and privacy. This is not about going away with consent altogether, but it's about finding ways to ensure that the consent and the personal data processing protections would not fall out of context, that they will not be something of the past. But admitting the fallacies of what consent is about now is the only way that we can move forward and find ways that to create or renew consent mechanisms for algorithmic processes. So when we talk about consenting, we need basically to think about what we're seeking consent about. So in the context of both machine learning and artificial intelligence, there have been proposals by scholars explaining that there are ways to basically explain a high-level purpose of what the process is about, or maybe find ways such as, for example, a recent proposal about providing counterfactuals to explain how what the purpose of the data processing mechanism is about. So basically functional interpretations of purpose limitations and purpose design. And to conclude, yes. So to conclude, in the problem of this friction between consented data and artificial intelligence is that first of all we need to go away from traditional consent mechanisms. That we need to create also some balancing checks between the social value of data privacy and also what the processing is about, and also this is something that has been that exists in the GDPR, that we need to balance the social value of what the data protection and also against innovation and the concept of the purposes of artificial intelligence technologies. Yeah, so shift the legacy of consent to a less formalist and more effective data protection, and that's all. Thank you.
Thank you. That was amazing. That was on the second. Yeah. Can we acknowledge that? We have 5 minutes exactly for questions, so shoot. If there are, yeah.
So, thank you. This was really fascinating.
Can you hear that? Yeah.
3 quick questions. One is, you talked about applying contextual integrity in machine learning. If you can share more thoughts about this. Second, when you talk about balancing mechanisms to the GDPR, one of the questions is whether you think that it would make sense to create or to initiate some public discourse about the cost to innovation that the GDPR involves. And here I'm thinking about some of the initiatives to talk about, some directives in the direction of promoting innovation, data innovation. And the third question is about consent. You put a lot of effort on in enhancing the mechanisms for meaningful consent, whereas maybe it's time to admit that consent, that the actual control of the subject is not
Yeah, talking about how to adapt a contextual integrity to machine learning and artificial intelligence, my thought process was reversed. So I started thinking about the proposals of basically coming from the right-wing explanation scholarship, thinking of how we try to articulate what the process is about, even if the right-wing explanation implies an ex post knowledge of what happened in the process. However, I believe that we can actually agree on some limitations of design, of explaining the design of an artificial intelligence, and put that into the contextual integrity theory to create a high level, basically, explanation of what the purpose was about. And I will.
So I think it was very interesting. I'm just curious to know to what extent there are proposals in the literature, or maybe you were thinking about it yourself. To what extent we can maybe start talking about delegation to maybe organizations or institutions that will treat consent as an ex-ante mechanism for validating processes on more of a social level and less on the individual level. Is there anything about that in the literature?
Yeah, well, that's... So I would qualify that closer to the paternalistic approach that want to apply actors such as we can use said organizations, we could say the state, or basically rely more on the social aspect, the human rights aspect of privacy, and not so much on the individual right and the individual autonomy of the control. So I'm not so sure that would work. I'm not, although I acknowledge the social aspect of privacy. I don't think that consent goes very well with collective consent. I do believe that it's an individual right, but also I come from a very European perspective where it's all about individual control. So I'm very much maybe affected by that. But I also wanted to say that, and also to come back to Niva's comments, that even in the GDPR, not all personal data are born equal. We have enhanced control mechanisms for some specific data, so maybe we can justify creating some granular approaches based on that. Yeah. Okay. Yes.
Very good short answer. I'm sorry.
It's okay. No. It makes sense.
I want everybody to have the same amount of time.
Yeah.
Tammy, you're next,
yeah.
right?
Can you just organize the slides this way, because I don't know how to do it exactly?
I love your name, but I'll explain later.
Katsabian, the last
No,
one?
Tammy.
Tammy. Okay.
Yeah, no, your last name is beautiful too.
Thank you.
Tammy is a PhD student at the law faculty of the Hebrew University in Jerusalem, supervised by Professor Guy Davidov. Guy. Your thesis focuses on the way the internet platform and virtual technology have influenced labor rights in a way that requires new understanding and redefinitions of basic concepts in this field, including fundamental workers' rights. And it focuses on the effects of the internet on three issues: the right to privacy of employees, working time, and freedom of association.
Thank you very much. So you saved the introduction that I wanted to say. So good morning to everyone, and thank you very much for having me here. I'm going to talk about employees' privacy in the internet age, AI and the human aspect. It's part of my, my PhD work. And when we are talking about this specific subject, we have some kind of a triangle. First of all, we have the AI revolution, and we talked about it a lot during the last 2 days. But also, alongside that, we have the modification in the behavior of the individuals. And it's also resulting from the new technologies, from the fact that we're having today social media sites and many new technological innovations. And both of those phenomena together are influencing the notion of privacy, the classical notion of privacy, private life in the workplace context. And they urge us to search for new ways of regulation. So that's what I'm going to talk about. So when we're talking about the AI revolution, first of all, AI revolution with its various new surveillance technologies enables the employer to supervise the employees at almost any time and in almost any place. It means that the employer can access the information on me, my private information, on several platforms. Also, private information which is relevant to time being, but also privacy information that was made on me years ago, that I was publishing years ago. Alongside that, AI also enables the employer to automatically process and analyze big data and to draw conclusions from it about the behavior and the character of the employee. So the employer can actually have some kind of a picture of me, my habits, my hobbies, my friends, when I go to sleep, all kinds of personal information that is accessible online. So how can exactly the employer do so? Several ways. You can vet all the information on me in the professional computer at the workplace, my email traffics, my professional email traffics, private email traffics more problematic because of the right to privacy, even it's in classical definition. Professional phone calls at the workplace, messages, but I'm mostly interested about the way by which the employer can vet my social media activity. The employer can use AI in order to vet the private information that I share, private information in the sense it's part of my private life, my personality, that I share online, and it can find this information about future candidates and about her or his employees. So I will give you a short example. This is Jessie, sorry. This is part of an article that was published less than a week ago in the Washington Post, and I will read you two paragraphs from it. When Jessie, this is the introduction of the interness of the preface of the article. When Jessie started looking for a new babysitter for her 1-year-old son, she wanted more information than she could get from a criminal background check, parent comments, and face-to-face interview. So she turned to Predictim, an online service that uses advanced artificial intelligence to assess a babysitter's personality and aimed its scanners at one candidate's thousands of Facebook, Twitter, and Instagram posts, and also comments. It means that even though I'm having a privacy policy which is very strict, once I'm commenting on other people's profiles, everything is exposed to this Predictim algorithm. Later on, they continue and say, parents could, presumably, look at their sitter's public social media accounts themselves, but the computer-generated reports promise an in-depth inspection of years of online activity. So that's the way it goes. AI can enable the employer, the future employer, to find a lot of information about me, which is available on social media sites. In the specific story of Predictim, they asked the consent of the sitters to vet their social media activity, but the sitters did not know that they will vet their social media activity by using AI. And they reached to crazy conclusion. Most of the babysitters were considered to be bad babysitters. I will not touch that. But what is most interesting, I think, is the fact AI can do so because there is a lot of information out there, right? Information that we shared from our free consent. So I want to focus from now on the human aspect and also about the question of regulation and the labor law perspective, how the labor law should regulate this new phenomenon, which is so unique to the internet age. So the human aspect, we live in public, and this is not a new phenomenon. Already in 1966, Edward Shields, one of famous sociologists, said that, talking about this paradoxical combination, people want to extend themselves by sharing with others what they know of themselves, yet at the very same time, in what they call the paradoxical combination, they want to share it in privacy. And think about yourself, right? We want to make connection, we want to make meaningful connection, we want to show our personality to the world. The main way to do so is to share information about yourself. But the internet age has increased this phenomenon, this human natural phenomenon. First of all, the core idea of Web 2.0 is precisely to create a collaborative virtual medium to enable people to communicate easily with one another. And the whole idea beyond social media sites is to share, to encourage people. Facebook encourages you to share more, to like other people's posts, to communicate, to collaborate, to expose yourself out there. There is a film, there is a film called We Live in Public that follows the life of the pioneer, John Harris, one of the internet pioneers. I highly recommend you to see it because I think it exemplifies very well this point of this need, this eagerness to live in public in today's world. So, how common is this scope? It's not a marginal phenomenon. I am sure you're all aware to that. But let's see the numbers. Pew Research Center published a study in 2016 that showed that 86% of the American people are currently internet users. And between the decade, another research of them showed that between the decade 2005 and 2015, the percentage of US population using one or more social network site increased from 7% to 65%, and I can only assume that today the numbers are even higher. Alongside that, another report of Facebook showed that as of March 2018, Facebook had 2.2 billion monthly active users on average. And another research, I think of Statistica, shows that as of April 2018, Twitter had approximately 233 million monthly active users, and Instagram had 813 million monthly active users. So it's not marginal phenomenon, but more than that, it's not only that people tend to share and participate more on social media sites, they tend to share more private, more meaningful information about themselves, their political view, their family relations, their need to be in touch with other people, something which is very private about themselves. And in this stage, we need to ask ourselves, especially when we talk about regulation, why? Why people do so? Is it something that we really want to protect on? So there are several reasons for that, and here I refer to sociological and scholarship. Sorry. First of all, it's the basic human needs, and I said it before. People need to do so in order to create new friendship, to stay in touch or reconnect with old friends. And today, in today's world, we know that the main way to do so is by being on social media sites, right? I assume if each one of you say, oh, I want to be in touch with my friend from high school, you won't search for her or his phone call, you will just search for him on Facebook. But more than that, we want to be part of a community, and today there are a lot of virtual, meaningful communities, communities of mother-to-be, communities of students, community of black people who struggle for the rights, of feminist women who struggle for the rights, students, etc. We want to feel a little less alone, and also, there are a lot of research about it that shows that people have less physical connections today outside in the real world, supposedly, and they have many connections online in order to feel meaningful and like they're having friends. And most importantly, it's part of the way we present ourselves to the world. But besides of all those basic human needs, we also suffer from several cognitive biases that encourage us to share more information online. First of all, people believe that information will be accessible to the specific community members. If I have a privacy policy, I truly believe that the privacy settings, I truly believe that the people who can access the information are only my 100 friends, but it's not like that, right? We can forward the information easily. When I'm commenting or even liking other people's posts who are public, the information is out there. It's not really private. And more than that, we have some kind of imagined audience or generic sympathetic reader in our mind, and we suffer from a present bias. We prefer to publish something now. We have this eagerness to publish it now, then think about the fact that maybe 10 years from now, my future employer will be exposed to this kind of information. But more than all, and Papachoripsy and Gibson describe it very well, we don't have much choice. Byte by byte, our personal information is exchanged as currency to gain digital access to our own friends. This is the main way we are living today. So we have some kind of a modern conflict, right? On the one hand, we have this tendency of people to share more information online, and at the very same time, they want to enjoy some kind of protection of the right to privacy through this information, because they want only the community member in which they publish the information to be exposed to it. And that's why we have all kinds of paradoxical understanding, modern paradoxical understanding of privacy, the privacy paradox, privacy in public, network privacy. But alongside that, AI technology enables the employer to supervise the employee, to be exposed to this information, to elaborate from it something, the general notion about the employee. So how can we balance between these two modern phenomena? And this takes me to the question of regulation. And the picture is because today, most of the notions on privacy are very, very flexible notions, exactly in order to grasp this difficulty. So we talked about the privacy's contextual integrity, but there are many other modern notions of privacy. What they are basically saying, and I'm extremely generalizing now, and making a very shallow argument here in order to explain it. Basically, if in the past, privacy was observed in a classical way. If I do something in my own private home, it's private. If I do it outside, it's not private. In today's world, I'm able, it's understood it's part of my right to privacy. When I'm doing things out there, it's part of my personality, it's part of my basic need. It can still be perceived as privacy. according to the specific context, the specific need, the specific norms, etc. So seemingly, the notion, the modern notion of privacy is stronger than the capabilities of AI, because even though I publish something outside, I can still enjoy the protection of the right to privacy in its modern way. And AI supposedly cannot win my right to privacy. But reality shows otherwise, of course, especially in the labor context. First of all, I think this is one of the main criticisms against the contextual integrity. It's very difficult to distinguish between the context, right? Think about your own profile page, Facebook profile page. I publish professional things there, I publish private things there. Maybe I'm changing the settings from every time in a while, but people are commenting. So it's very difficult to say when my behavior online is totally public, totally professional, and when my behavior is totally private, especially when you talk about judges. I don't trust that the judges will make constant, clear decision regarding my right to privacy when I have something which is so flexible. But more than that, in a more practical level, AI can be used without my awareness, right? The employer, my future employer, can use, and he or she are actually using, AI in order to process all the information which is available on me online. I don't know that. And the flexible notions of privacy, it's nice in the theoretical level, but it doesn't give me practical tools in order to protect my right to privacy, right? And the legal world requires stability and certainty, and this is especially true within the particular employee-employer dynamic of the workplace in the fluid and chaotic internet age. That is why I'm offering to add, of course, we still need a flexible notion of privacy. They are very meaningful, and without them we cannot make change in the world, but we also need a procedural approach to the notion of privacy, a clear procedural protection to the notion of employee privacy in the internet age. I'm offering here 2 concrete procedural rules. I have another rule that I'm offering in my article, but it's less relevant to AI, it's relevant to the notion of privacy in the internet age. And of course, we can imagine more procedural rules in this regard. So first of all, it has to be at the beginning, the end, and throughout the employment period. The first rule is having an anonymous job application process. It means that my name, online application, there are more and more processes of online application, my name will be deleted. And in this way, we can balance between the employee's right to private life, because the employer cannot Google my name and use AI in order to search private information on me. And in the very same time, the employer still enjoys prerogative, because all the information on me is available on CV. And once I will have the interview, we can ask my name, of course, and later on Google my name, but at least I have a fair chance to present myself without all this history online. And it was previously proposed in several countries in order to struggle against classification. It was not about the name, it's not about Googleism. It was in order to struggle against classification, racism, sexism, etc. So all the details that were relevant and could expose my gender or my ethnicity were deleted from the CV. In France, in England, there are some examples of that. It was not very successful back then because it was a large amount of information. The second procedural rule, and with that I will end, is to have a clear rules for every workplace or privacy and social media policy. It means that the employee and the employer representative, not the individuals, of course, has to sit together and set privacy rules and to know exactly what I'm able to publish on a social media site if I'm the manager of the organization and if I'm just, a clerk in the organization, and what the employer is capable to do regarding my private information. Everything is clear, everything is transparent. I'm talking about the mechanism, which includes a semi-mandatory arrangement. The original arrangement is written from a pro-employee perspective in order to protect the employee's rights to privacy. And the employer can modify this arrangement and set privacy rules in accordance with the specific workplace nature, position, etc., together with the employee representative and only based on their consent. And the employee representative are the one who can also ensure compliance. Sorry, cooling off period, I will not talk about it. Last slide, so just summarize with that. The procedural framework, I believe, enables us to protect labor rights in the internet age in a way which takes into account all the relevant things, right? The unique power dynamic of the workplace, the implication of AI along with the vast participation on social media sites, and the need for legal stability in today's world. Thank you. Sorry for stealing the moment.
Thank you.
Can I have a pen?
That was a lot of information as well.
Can I write on your page?
Time for some questions.
Can I have a pen? I'm
Yes.
sorry, I forgot it. And a paper? Thank you.
Do you
Sorry. Okay. Thank you. Yeah.
Yeah, thank you so much for the talk. Very interesting. It's very nice to meet other scholars who work on labor. I work on social media at the workplace in Germany, which is a very specific context because there are so many workers' rights when it comes to surveillance. And I'm really interested, I'm not a lawyer, that's why I'm asking you as a lawyer. I'm really interested in a global governance perspective and in the context of interoperability of different privacy rights and also different privacy cultures and understandings. How, for example, an organization like the International Labour Organization can push forward guidelines internationally in this regard. Do you think there is a chance for that, or is it unlikely?
Okay, so answer it in two levels. First of all, it's a very good question. I totally agree with you. There are different cultures around the world regarding the right to privacy, and Germany is one of the most, I think, progressive country when we are talking about privacy. They have even a right to personality, which means that I can enjoy the right to privacy within my workplace, and we cannot imagine something like that in the US. So it's difficult to talk about the right to privacy in a very general international meaning.
Can I?
Yeah.
I
Follow up?
You were talking about that you have very strong workers' rights. It's not just about privacy. But
I agree.
there are some
Yeah, the
context of
combination
Into
of
Europe,
like
yeah.
the privacy
Yeah.
and the work.
But also in Europe, in Germany specific, it's not only labor rights, it's also the notion of privacy. It's very strong there, so the combination is very strong. But you're asking about enforcement maybe or regulation in the international level. There's a lot of writing about that, and I don't have any clear answer because on the one hand, there's all this writing about new governance and our ability to create something which is not like the formal ways of regulation. But on the other hand, I think on the ground, we still need the state, we still need the local tribunals in order to enforce labor rights. And we can have those, push from upsides, from the national level, and from downsides from the community, from labor rights in the specific state in order to make those things being enforced. But I think we cannot just, say, yeah, we can go to the international level, the new governance cannot stand by itself.
one more quick question to the first, I think.
Okay, two quick comments on the problem and one quick comment about the solution. So for the problem, I think you also need to include the reality of errors. So for example, a few months ago, I found out that my picture was used in a fake Facebook profile, which was trolling people around the internet, and one of my friends saw my face on our website with really disgraceful comments. So I think that's one thing to take into consideration, especially in the reality of bots and fake profiles. And also inferences. So even if you do not disclose specific information, specifically because you mentioned that they're using AI, when they scan your profile, they are able to make inferences about you, about information that you didn't even disclose, like your, I don't know, sexual orientation or your religion. And about the solution, I think anonymization is not enough because of proxies.
You think what's not enough? Sorry?
I think anonymization.
Anonymization.
Of course. Deleting the name like
Yeah, yeah.
you proposed is not enough because of proxies. You can still have a very racial or discriminatory reality even if the name is deleted.
Okay, so thank you for the first comment. I totally agree with the second one, but I think that eventually, I will do it very quick. I think we're eventually living in a world in which we need to balance between all kinds of prerogative and rights, right? And at the end of the day, we are having procedural right, which is not perfect. But I think that without this procedural right, the situation would be even more problematic. Because think about it. Now they can just Google the name, and they can have all the information available on you online. So it's not solving totally the problem, but it's at least giving a specific tool to the employer to protect a right in a very specific stage.
It's a good start, but just acknowledge those weaknesses.
Yeah, you're totally right. Thank you.
Okay, thank you. Where do you want to sit there? Yep. It's a bit timely, huh? Luisa. Is that Scarcella? Perfect. You're a PhD candidate at the Department of Tax and Fiscal Law of the Karl Franz University of Graz.
Yes.
Where you've been working as a research and a teaching assistant. Your thesis concerns tax treatment of cryptocurrencies, with a special focus on Bitcoin and blockchain technologies. You've been focusing also on the digital economy and the impact of AI on the labor market from a tax law perspective, which is very interesting to me. You're also one of the coordinators of the Finance Law and Economics Working Group of the Young Scholars Initiative, INET.
Thank you very much. Thank you, Aviva, for the presentation. Yes, thank you. You are. Yes, and thank you very much for having me here today. As you said, I work at the tax law department of the University of Graz, where we have a special focus on digital economy, and we analyze the digital economy from a tax perspective. And today I'm going to talk about something different from my PhD dissertation, which is profiling automated decision-making in tax matters. We've been working, so we are in an initial stage at the department on this topic, so any suggestion is very welcome. My supervisor is working more on big data and nudging, but today I'm focusing just on profiling automated decision making. Okay, so first of all, tax base and technological. Oh. Okay, because I tried before and it was working.
Maybe you just need to draw it with the quicker and later on.
Thank you so much.
You're welcome.
Thank you. So yes, so tax base and technological development. So during the last years, the 50 years, we didn't see just an innovation process, but this innovation process also affected the way tax agency can assess our tax base. And also, we assisted in the last 50 years, more or less, also to more globalized economy, which means that our economic activities were carried out in more than one state. So if we think about the generation of our grandparents, they probably have the same job for a lot of years. They're very statical, maybe, and the income can be assessed very easily because just in one country. Then if we think about the generation of our parents, maybe they started to have economic activities carried out in more than one state, and so the assessing the income was becoming a bit harder. So exchange of information between tax administration of different states and information from third parties such as banks, financial institutions became very critical for tax administration in order to assess the tax base of taxpayer. And then if we think about last generation with the sharing economy and internet platform, but also think about the influencers on YouTube or other social networks, where they produce a kind of income, and for tax agency it becomes even more difficult to assess this tax base. So in order to deal with all these different type of incomes, these incomes derived from different parties and different states even, tax agency had to rely on technologies. It started to receive a lot of information, both from taxpayer, but also from third parties. And in order to assess this information and proceed this information, it started to use also technological tools. So we have technological development that made it a bit harder for tax administration in order to concretely know what was the income, but tax administration at the same time started to use technology in order to assess this type of income. So, if you think about what is the first thing that comes up to your mind when we talk about tax agencies and ICT, is probably the platform that you use for filling in the form for your tax return. So we started with taxpayer filling tax returns, written tax return, to pre-fill tax returns, meaning the tax agency used the information that they got with previous tax returns, and they pre-fill your tax return, and you just insert your data, so you give additional data to the tax agencies. But also they receive data from third parties, such as bank institutions, but also the employers, for example. And then how do they use this information? Well, they mostly use this information for risk management, for auditing, so to decide which taxpayer has higher risk of tax evasion and which taxpayers should then be audited. Why? Because it's so hard for them to assess every taxpayer. It's kind of impossible. So they have to carry on a sort of risk management assessment. And here is an example, for example, of the Austrian tax office, where they use technological instrument and risk management system and algorithm to classify taxpayer on the basis of the risk for them to evade taxes. And they do that through the information that they got from third parties, from taxpayer, but also right now, if you take a look at the one of the report of OECD on technologies for better tax administration, they also refer to big data and the possibilities for tax agency also to go through the internet, Google, and social networks to find out if the income declared is actually the actual income. So the advantages of ICTs for tax matters is to provide readily accessible historical data, reduce mistakes, promote voluntary compliance, control risk management activities, and improve service delivery. Now, what I talk about, especially in the example of the Australian case, was a classification of taxpayer based on the data that the tax agency receive from the taxpayers and third parties. So basically what they're doing is classifying taxpayer, and this can remind us of profiling. And now, well, very recently we are all aware that the GDPR entered into force, and so my idea for this paper was to go through profiling and automated decision-making under the definition of the GDPR and look if actually the techniques used by the tax agency can be included in these definitions, and then which are the limitations, the restrictions to the GDPR provisions for tax matters, since there is a public interest which is very strong and it's fighting tax evasion. Okay, so profiling under the GDPR, well, the GDPR defines profiling as consisting in any operation or set of operation which is performed on personal data or sets of personal data, whether or not by automated means, such as collection, recording, organization, structuring. Okay, so far I basically recall what we have just said about the collection of data by tax agency. It has to be an automated form of processing. They use ICT in order to process all this data because human could not be able to do it right now. It has to be carried out on personal data, and the data that the tax agency receives from the tax return are also personal data. And the objective of profiling must be to evaluate personal aspects about a network person. And actually, this is what they are doing with this data. They are trying to find out if the income declared is actually that income. So according to Article 29 Working Party, there are potentially 3 ways in which profiling may be used, which is general profiling, decision-making based on profiling, and solely automated decision-making, including profiling, which produces legal effects and similarly significantly affects the data subjects. And this is the definition provided by Article 22 of the GDPR, which states that the data subject shall have the right not to be subjected to a decision based solely on automated processing, including profiling. So now the question is, well, now that they have created these profiles of taxpayer, there is an algorithm that will tell the tax agency, okay, these are the taxpayers that have higher risk to evade taxes, and so these should be audited. So then an assessment notice is produced by the tax agency and sent to the taxpayer. The question is if this tax assessment notice is actually is the fruit of a decision which is based solely on automated processing. So there are 3 elements that we need to check first about automated decision making. Automated decisions can be made on any type of data, and this perfectly reflects the data that a tax agency have, so data provided directly by the individuals, but data observed also by individuals, and derived or inferred data, such as a profile of the individual that has already been created, such as the pre-filled tax return, but also information that they got from other public agencies. Then another important element is the human intervention element. The Article 22 applies only in cases where decisions are made in a solely automated way. So if there is a human intervention element, Article 22 should not find application. Now, is the tax assessment notice, which is signed by the employee of the tax authorities, a significant human intervention element? Actually, there was a speaker on Tuesday talking about this super expert algorithm. So a tax employee, when he received the results from the profiling and the algorithm applied to this data in order to evaluate whether this taxpayer should be audited or no, we just trust the result. He will will trust the super expert algorithm, and I will just sign the tax assessment notice. Also, like for example, in Italy, there are tax assessment notices that are forwarded to the taxpayer where they say this is made by an automated processed method or technique. So actually, we can see that it might be that the employee, there are some things that actually caught his attention, and he can go for further investigation. But usually, they sign the assessment, and then the kind of human intervention happens ex post. So in court or during mediation, depending on the countries and the procedure and the challenges that they offer to taxpayers. The other element is that legal, so the decision and significant effects of the decision. So actually, if we look at the recital 71 of the GDPR, so Article 22 refers to decision, but the recital use the word measure, which also might be, okay, perfect, that it might not be a decision which is a final decision, but can be also like a measure such as the assessment notice, which can be challenged afterwards. And significant, well, of course, there are no doubts that even if we don't stick to the definition of decision, because it's an assessment notice, actually, these still have, even if it has still have significant effects on the taxpayer. Now, data processing and taxation, actually, the GDPR refers to taxation and public task, public interest. So the Article 6 GDPR litera E is about, well, Article 6 is about the lawfulness of processing and says that processing shall be lawful only if and to the extent that at least one of the following applies, and it has a list of letters. And letter A refers to the performance of public tasks, such as the one carried out by the tax authorities. And actually, this processing is allowed if there is a legal basis in EU and member state law. However, there must be these information which are listed in the slide. So general condition governing the lawfulness, types of data subject to processing, considered data subject, entities, storage period. Then Article 22, well, the second paragraph says that there is no application of Article 22, first paragraph, if the decision is authorized by union or member state law. The right of the subject described in Article 22, paragraph 1, will not find application if there is an authorization by union or member state law. However, the law shall lay down the suitable measures to safeguard the data subject's rights and freedoms and legitimate interest. Now, most of the techniques, the instruments that are used by tax agency, of course, find the legal basis. So there are member state law that says that the agency will process this data and will use these techniques. However, these laws also have to lay down the suitable measures to safeguard the data subject's right. And the question is also which are these safeguards and where we can find these safeguards. So if we look at Article 23, it's also like address the restriction to Article 22nd and says that when such a restriction respects the essence of fundamental rights and freedoms, and it is necessary and proportionate measure in a democratic society to safeguard. And it also includes taxation matters. Article 23 says that it can be restricted, Article 22, but the laws must contain specific information such as the purpose of processing, categories of processing, categories of personal data, the scope of the restrictions, safeguards to prevent abuse, and so on. Well, these data are particularly important, and these information are particularly important because right now, as I will show later in another slide, is that, well, state adopted the new GDPR or implemented the new GDPR, adopting a law on data protection, but then they also have to go through the single laws regarding taxation and these instruments and make sure that these laws contains this information, because right now there are several laws providing for these for the techniques to be used by the tax administration, but they actually don't report all this information. The safeguards. So safeguards, well, they're not clearly stated in Article 22nd. We have this information contained in 23, or the information that needs to be there, which are the one listed in Article 6. But we also can use the, as a guideline, recital number 71 of the GDPR, which says that there are specific data subject rights. So they have to obtain human intervention, expresses their point of view, obtain an explanation of the decision, and challenge the decision. Of course, recital is not binding as the text of the regulation of our directive. Recitals are interpretative measures that can be used by member states. And of course, we can use also the case law that we have based on tax matters and the relationship with Article 8 of the European Charter of Human Rights and Article 8 of the Charter of Fundamental Rights of the European Union. But however, I will skip this slide. There are different safeguards in different member states. Like the level of safeguards is not the same among all member states. Of course, they will have to introduce this information, and they were listed in Article 6 and Article 23. But however, the different level of human intervention or other safeguards are different in different states. So of course, here there is this, the need to balance and strike the balance between what is a public interest and fight tax evasion and tax frauds by using new technologies. And these are important tools, extremely fundamental tools for tax agency. However, we need to safeguard the data privacy rights of taxpayers. And the question is also how to agree on the safeguards on a European basis. Why? Because also we have different economic activities going on in more than one countries. There might be joint audits, meaning that employees from different tax agencies will audit together one taxpayer, and so there will be different protection or level of protections. Next steps, in the tax world, we are talking about taxpayer charter for a long time right now. Of course, this should be including also a privacy right, as already domestic European, at the European level, domestic taxpayer charter have. But maybe the question is also to take into account the relationship between what fundamental rights for taxpayer are and the relationship with new technologies. And that was all. I tried to make it short, sorry. Thank you so much.
We have time for some quick questions. Yep.
Thanks very much for an inspiring talk. I think the case that you have made, that this is a very prominent example of automated decision making, and in this case for the GDPR rules, whether they are really bringing some help to protect the interests of the data subject. And my question is, does the system provide enough information for the data subject to decide whether it is an error there, that he or she can complain and say, I need a human intervention, I need someone to look at that. I think that's a very important thing, because if it's just your feeling, oh, it's too much, then everybody could do that, and then the whole system would break down, because the efficiency gains that we have from this automated system would not work anymore. So I think the very important point is, does the system give the data subject enough information to say there's something wrong, I need a decision by a human?
Yes, thank you very much for the question. It's a very interesting question, important, as you said. So what happens is basically that I don't think the data subjects get the information about, oh, there is an error, there is a mistake. They receive the assessment and saying, okay, these are the mistake, well, these are the reasons why we think the declared income is not your actual income. And then based on the reasons, you usually challenge and you prove that you go to the tax agency. Then the procedural rules are very different from country to country. So you could directly go to the tax agency, or maybe you have to go to court. But you will try to demonstrate, no, actually, these are my receipts. These are why actually the income that I declare is actually what I declare is correct. Okay, no, because the other thing is also that actually for the employee to verify, oh, the algorithm actually made a mistake. Maybe I should look up the older tax return. Yeah, that it depends on the system. Some system also like point out that like there is a quite high difference between the tax return that is made that year in comparison to the older tax return. So that could be like a signal. Okay, maybe I should look out if there is something more. Thank you.
No, I thought, because I thought another interesting part of your question is the fact that the GDPR gives this right to explanation regardless of whether there is a mistake or not.
Yeah.
And so I thought you were interested in how you think about that.
Yeah, well, the explanation, also like one point that I didn't have the time to develop in this paper regarding to the explanation is also how much information on how the system works should be given to the taxpayer. Because one other concern is that if I explain too much about how my system works, then my system will not work and you will be able to behave accordingly in order to circumnavigate my system, my electronic system.
Thank you. I think we have to move on, but save your question because we might gather some time along the way. Let's do that. Want to sit here? Just in case I would. No, that's okay.
Like, it's just...
You want to?
The what?
There.
Okay. You're leaving.
Taking you then. Eduard, Fosch, Villaronga. You'll be starting as a Marie Curie postdoctoral fellow at the ELAW Center for Law and Digital Technologies of Leiden University in the Netherlands. You're also the co-leader of the Ethical, Legal and Societal Issues Working Group at the European Cost Action something? Is that just the European Cost Action or is there a group? Oh, yeah, right, on wearable technology, that was missing you. Previously, you were a researcher at the Microsoft Cloud Computing Research Centre at the Queen Mary University of London in the UK and the Law, Governance and Technology Department at the University of Twente in the NL, the Netherlands. You have quite a long CV. I'm going to skip it up to here and give you some time for your presentation.
Thank you so much. We will do first one attention exercise. Can you everyone get up 1 second, please? Perfect. Raise your hands. Yes. And shake it off. Done. Thank you so much. So I saw this in one conference and I decided that I would do this all the time. So sorry, because it brings people attention to the presentation and not to their personal devices. So hi, I'm presenting today this paper. It's an interdisciplinary collaboration between Heike, that is from an ethicist, Christoph Lutz, that is around, he's a sociologist, and then Aurelia and me, that we come from the School of Law. And we try to understand what does transparency mean in AI, but also from different perspectives. So those coming from the School of Law might think that this is not pure legal and so forth. But this is the beginning of a collaboration, and I think that on the way will come to much more sense. So I will first start with a quick introduction, and then we will see like different approaches to transparency, and then I will just conclude with our proposed model on how we could approach this interdisciplinary question in our opinion. So let's start. Let's see if this works or not. No. So when you look at the dictionary, transparency basically is a noun that says that it's the condition of being transparent. And then when you actually look at transparent, this might seem very obvious, right? When you look at the definition of transparent, they say that it's an adjective, and the second one is that it's easy to perceive or detect. The funny thing is that when you look at the computing meaning, it means that it's a process or an interface functioning without the user being aware of its presence. So I don't know what's your impression, but when we looked at the dictionary definition, we thought that it was a little bit contradictory to what we think about transparency. So I will give you an explanation on like why AI is a little bit different from other technologies. So right now we have an overuse of a screen technology. We have screens everywhere. Your washing machine has a screen, your fridge, your mobile phone, and many other technologies, your car. And people start to identify this as a very common situation. So a family that they are spending quality time just interacting with their screens. So what happened is that they realized, like, there are different research trying to understand what's the impact of screens that have on our human behavior. And this basically ranges from like being less creative, or that ruins our sleeps, or that makes us much more distracted. Actually, there's a lot of research also like on how this is impacting our brain, and I have one paper talking about this. The effect of this actually is that time ago already, like Mark Weiser already said, that the most profound technologies are those ones that disappear, those ones that weave themselves into the fabric of everyday life until they are undistinguishable from it. So what we will see is that the more and more we will have a lot of technologies that will be part of our daily lives, and that we might not be much aware of what are the capabilities of such technologies. Do you know what's this? This is Nest, can you? Yes, it's a smart thermostat, okay. It processes a lot of information. Users might not be aware of the different data flows that, that this has. Do you know what's this? Roomba, yeah. What's Roomba? What does it do? Yes, a vacuum cleaner. Well, I think that it is like a data processing connected to the cloud with camera vacuum cleaner. So what happens like with these technologies basically is that users just focus on the use of these technologies, and we might think that this is a robotic vacuum cleaner. But what happens here is that when we think about cloud robotics, for instance, there's a lot of robots that use cloud services in order to have much more power. So they use, for instance, navigation services. And navigation services, it could be Google Maps or any other services. But right now, there's not that much data about indoor spaces, because all those cloud services focus on outdoor spaces. So all the information that Roomba has, it's really rich in indoor spaces, and that for navigation purposes and obstacle avoidance is very important for robot technology. So we were wondering also with I don't know, yes, we were wondering with especially with Heike, because she has been working with the Mario project. It's not working. It's just like a I don't know. It's just a small video. It does not matter. So basically, like what we, oh my God. So, oh my God. Yeah, pause it. Sorry. So, yeah. So I mean, we were just like wondering. I don't know if, yeah, there should be. Yeah. Well, it does not work. It's fine. So basically, we were wondering, like, what does happen when we interact with robot technology in different contexts. Oh, now it's working. Okay, perfect. So so normally, like, the use of robot technology, like, it will really depend, but they have been inserted in nursing homes, in elderly care. So there will be like a lot of different users like interacting with this robot technology and focusing on doing certain exercises, but not really like understanding that some of the part of the information flows are happening somewhere else, maybe in the cloud. Apart from understanding that there will be like these growing screenless uses and like these like different type of interfaces, what we realize also is that the AI ecosystem is really large, and there are many different people inside this ecosystem that might have very various different understandings of the same concept. So when it comes to transparency, it could be possible that maybe the developer might think that they use transparency to understand if the system works properly, to identify and remove errors. But then when it comes to the user, maybe it will be like in order to provide a sense of what the system is doing and why, also to allow and check whether the system worked properly. It could be also interesting for the regulator because they want to provide the ability to audit and to predict whether a decision has done or provided any harmful result, etc. And also, it might have like also interesting in different parts of the society. So, in our work, what we did then is try to understand, like, from different disciplines, ethics, law, and sociology, try to understand, like, what is the concept of transparency and whether there are, like, some links between them. So Heike is the one that has been, like, talking about ethics, and actually she says that the ethical underpinnings of transparency come in the informed consent. And actually, like, informed consent, it means that it allows a person to have a meaningful choice in what happens to them. But then also she makes this connection between transparency and trustworthiness, and this goes very related to what Luisa was saying, right? Like that somehow when we trust someone, we have like this goodwill, right? That then we rely in the other person in face of the uncertainty of a risk of harm. But there are like a lot of different authors that highlight that that this trust actually has this inherent risk and makes visible the subject vulnerabilities. And actually the quote says, where one depends on another's goodwill, the taxation agency, one is necessarily vulnerable to the limits of that goodwill. There are other researchers and ethical and legal aspects saying that actually transparency, what it makes, it's that it prevails seeing rather than understanding. So I don't know if you know this picture, but it is the Las Meninas de Velázquez, and basically what you can see here, and even the title, it comes about the Las Meninas, right? So like these different women here at the beginning. But if you look closer, like, and you try to understand a little bit more, like the picture, you see Velázquez, that it is over here, and that it's actually painting the couple that it is in this part, in the mirror. So there are like different authors that actually say that transparency can not only used for genuine like trustworthiness, but it also like can happen like it has like different consequences. And Anani and Crawford say that it can be harmful, create false binaries, technical limitations, and as we say, it prioritizes seeing over understanding. So transparency in the GDPR. I will kind of walk quickly because we may know this. But there are like a lot of curiosities. In the directive, it was in a recital, and it was directed to supervisory authorities, but not to data controllers. In the Madrid resolution in 2009, actually it was decided that transparency would be like one of the principles that govern the use of personal data. And right now it is in the Article 5.1a, and that actually like this makes us understand that it's in close connection between transparency, lawfulness, and fairness. Some curiosities: this transparency requirement right now has been defined and precised in different recitals, 39, 58, 60, 71. But it also has moved to the chapter number 3, which deals with the rights of individuals, and this may give us reasons to believe that transparency is seen as a foundation for the exercise of other rights, but also in keeping a close link between transparency and personal autonomy. So these are like the link that we make with the ethics tradition in our paper. Transparency can come like from prospective transparency, so we inform a data subject about the data processing beforehand, or retrospective, so like giving the ability to allow a step-by-step follow the data processing. What we say in the article is that it needs to be ensured that it is like within the whole life cycle of the data processing. The GDPR concretizes exactly what does it mean to be transparent, and they say that the data controllers must inform their customers through concise, easily accessible, easy to understand, and clear plain language. The information must be provided in writing or where appropriate by electronic means. And we highlighted this in our paper because what we will see is that when we do not have this support, when we cannot really give any in writing, then we might not really know like how to apply these concepts into technologies that have no screen or that they have other types of interfaces. Articles 13 and 14, who, how, when, why, and what for is this data processing. Right to explanation. This is very quick. I love this video. Like there has been like this. I hope it can be played. It's just a joke too, but it's like this drama, you know, in the legal community going on whether it exists or it does not exist, the right to explanation, and so on. It is quite funny. Now there is even like the inference, the reasonable inferences, and so like it reminds me like of a South American telenovela, but. What we say in our paper is that it's very similar to what Selps and Pauls say. I will come here, but we just put like this chart. Like for us, it does exist actually. Like and actually, what they say, Selps and Pauls, it says that meaningful information about the logic involved breathes the existence of the right to explanation, whether one uses the phrases or not. Going to the human-computer interaction and human-robot interaction, what we realize is that existing research is focusing on how much people know about data protection and data collection. So actually trying to understand what is the awareness of data protection. Also, what are the outcomes of such transparency? So what happens when systems are transparent, and for example, in terms of trust. And normally what we realize is that in human-robot interaction and human-computer interaction, it is understood transparency as explainability. That's why the right to explanation for us in the paper, it kind of goes through the link on like what does it mean transparency to all these like three communities. So there, what the main findings of this is that actually the perception and attitudes towards transparency really differs depending on the technologies that are being investigated. So for instance, when it comes to music recommender systems, the users actually find that it is very okay. But the emotional sharing from the robot to the user does not necessarily imply feeling closer to the robot. And we have like different charts. I don't know if the version that it is in the conference have, but some charts like with this understanding of the technical community, trying to understand like transparency, that it is focused more like on the robot design to support human understanding or the human understanding of the robot's behavior. So what we realize, and I am finishing actually, is that we need this more holistic multi-stakeholder model for AI and robot transparency. And it is based on the anatomy of an AI system of Cruz and Anani. Basically what we say is that when it comes to dealing with transparency, and it might be applicable with other precepts, but what we say is that basically like there are like two different sides. There is like the supply side, so actors that being involved in developing, deploying, and discarding also AI system, which actually they say they are the ones that need to be transparent and that need to supply this transparency, but also the demand side, like these actors that are going to require like transparency, stakeholders, governments, etc. And this needs to be like through like the different phases of the development of a technology, because as the literature shows, depending on the technology, this concept may vary largely, and also the opinions and expectations. So conclusions, I was given like this mug from a very good friend of mine, Aviva. I think that technical people do not like this, but because I've been criticized in another conference. But actually, like what I'm trying to say is that the meaning of words are important, but the meaning of concepts and the applicability of these concepts in different domains are also very important if we really want to ensure the protection of users' rights. and nothing. I will close here because otherwise I've got this, but these are just like the conclusions, that there are miscommunication between disciplines, that there is the need of a legal validation of technical practices, that there is a strong demand for giving content to legal provisions that are often vague and abstract, that this needs to be a collective effort, and that this paper is the beginning or the start of this, and in this concrete case, and that we definitely need a life cycle protection. Thank you so much. Of everyone. Thank you so much.
Thank you. Some quick questions. I haven't heard you yet. It's only fair.
Thank you for your presentation. It was very interesting. I was thinking about the definition of transparency and sentence in faculty. In computer science, transparency had been considering always a concept related to software or a model or whatever you want. And a model is transparent when it works. Okay, so you don't perceive how your washing machine works or how your computer works. So we really don't know how our phone works. So
Yeah, so it's a process or an interface functioning without the user being aware of what it works, right?
yeah, but I think that this definition of transparency in computer science had worked until, I don't know, the last decades or the last few years. But how you think we have moved to the new definition in which we need to know how it really works, or we need to be aware of the technology.
So basically what I... Yeah, just very quickly. I think that it's a very long process. That's why in the presentation we come like from the directive. In the 95, that was not even the case. Then in 2009, it is considered as a core principle. And then in the regulation that it just like become binding now, it is really there. So until it will really come to the application of this in real cases, it will take time. What I'm here to say or like to claim to policymakers is that definitely people developing technologies need much more guidance on like what these principles mean. So the concept has been also evolving, and also like the importance of this concept has been also evolving. Especially like, yes, between the transparency and the privacy and like how these mingle together. And that's why like the supply side, because it might, from one side you might want transparency, but on the other one you might want privacy. They are mingled, they are different. If that answers.
Thank you for this rich conversation about transparency, and I'd like to follow up in the same direction of this question. So I'm really skeptical about, and I think that your presentation convinced me that the idea of transparency in the GDPR is inconsistent with what it tries to enhance. It just creates bureaucracies that doesn't really help to
I agree. It's important to know why.
I'm not sure it's important to know why. I think it's important to know what the value that we're trying to protect. And if we want to protect that we are being treated fairly, let's look at not at transparency, let's look at fairness. We want systems to be fair. Let's check whether they're fair, right? Let's look at the outcome. Are they discriminating women? Are they discriminating on the basis of class? Are they doing, what are the wrongs that you try to prevent? And let's measure that.
That's a very good point too. And I think your point is very clear. Transparency is a tool rather than a goal in itself. Do you want to reply to that really quickly?
Yes, just to say, so because in European law we have data protection and privacy as two different fundamental rights, I also think that in this case it's also like transparency and fairness. They are like kind of two different things into the same provision in a way. So you're totally right. Like I do not understand like whether legal scholars need to focus on this and say like no, the policymaker said that, like that is really important, on say no, you know what, like really what matters here is fairness. Like that is what we should be focusing on, because then otherwise our attention, it is like completely focused on like being transparency or not. But then as you're saying, then you can be totally transparent, but if your system is totally contradictory to the protection of like fundamental or basic freedoms and rights, then yes, then we are really like in the wrong side. Thank you.
Do you want to sit here or do you want to stay there? You want to make sure that we know who you are. Finally. Leilane, is that how I pronounce it? Leilane. I have a cousin with the same name, so I'm really happy to be able to say that. Leilane Cruz graduated from this in social communications at the Federal University of Pernambuco in Brazil. As a master's degree student at the Federal University of Espirito Santo. You're interested in philosophy of technology. You intend to investigate connections between technology, capitalism, state, and domination in order to understand how digital technologies, how the use of digital technologies can support real democracy on societies. Specifically, you research corporate social networks and hate speech spread through fake news. Is that correct?
Oh.
Okay, no. I thought I just read somebody else's bio and you were
No. I was worried by the presentation. Thank you. Thank you for the presentation. Well, can you hear me? Right. Yeah. This the idea of this paper is to address for me, a main issue when we talk about privacy, when we talk about user experience of the internet, when communicating through the internet. For us, identity validation is the key factor of internet usage these days. There was a transition between usage of communication tools before, when the internet was all wild and there was no regulation, and now after Web 2.0 and platformization of internet communications, communications through internet. So there is an anonymity and struggle for internet territory that for me is based on anonymity or not anonymity. Closed platforms that we call walled gardens, as social network platforms for me are an example. They are surveillance territories. They are territories that are built to create an atmosphere of sharing, but an atmosphere of sharing where people are surveilled and spied all the time. And there are anonymous networks and anonymous platforms, platforms that are willing to provide an environment for communication, but without data collection, without compromising anonymity. So artificial intelligence applications those days in communicational platforms, mainly the corporate ones, is for life scrutiny through for-profit purposes. For us, this is a really terrifying issue. So we make this distinction between privacy by policy and privacy by design. In privacy by policy platforms such as Apple platforms, such as Facebook, such as Google services, data collection is a prerequisite. You need to inform your identity. You need to give sensitive information for these companies in order to enjoy their services. So in Steve Jobs' words, privacy means that people know what they're signing up for. That is what we can define as privacy by policy, because you read the policy, the privacy policy of these companies, and they say, oh, we maybe can be sharing your data with third parties, but we do not necessarily say tell you which are these third parties. And Steve Jobs was really clever when he said that, because he was criticizing at the time Facebook. It was in a conference in 2010. He was sort of criticizing Facebook for not inform the user properly about what they did with their data, as he claims Apple does or did at the time. And privacy by design, platforms that took privacy as a prerequisite for developing tools, they do not collect data by default, and this is for us an interesting position while develop technology. The paradigm is an absolute privacy by design system. This is a Tor project position regarding privacy. So it is possible, when we talk about technology, that we design platforms that have privacy as a priority concern, as a primary concern. So we have a process of annihilation of anonymity towards control. There is a technical dominance of large social networks led by technical choices within a logic of self-preservation. Right. These platforms, in order to maintain their hegemonic, their hegemony in communication processes with the internet, they only use or develop technology in order to continue to maintain user attention and to grow their business, their hegemony in communicational processes. So technical elements arrangements when you develop some technology, like when you project a computer or when you project a radio transmitter, technical arrangement of kind of neutral elements like electronic circuit, the arrangement is not neutral. You may have a mathematical model, or you can have a electric circuit. These scientific elements, these theoretical elements, are not necessarily biased, but when you arrange them in a certain way, they automatically have a bias that is I'm sorry, I'm a little slow, but I'm trying to find the right words. But you understand, right? The developer has a role in arranging somewhat kind of a neutral elements in order to deliver a product. So there was, at the time where mass communications were the proeminent way of communication, so we communicated through television or radio, there was like feedback technologies like mass research. You would make a survey with the users, like, oh, I want to know whether television television viewers like it or not a show, so you make a survey. This kind of technology were what we call, actually not me, called mass feedback technologies. And now we are turning to individual level feedback technologies, because this when you combine artificial intelligence and the social platforms, you have the possibility of these platforms to understand, to have data about your whole activity. So it's a whole new world for consumer targeting, for understanding your client, your consumer, right? So these social networks, they made this transition from an internet environment where you didn't have, you have anonymity, not in identity validation, where you did have in a world where we had mass communication media, to a world where you have individualized communication and individualized targeting of content based on our prior life data. It's like they have this dual characteristic of a computational characteristic of collecting data and a communication characteristic of we sharing our communications through these tools. And they have, there is another issue regarding these corporate social networks. We are Facebook's employees, but we don't have payment, or because we provide the materials for them to model their product. They sell our profiles to third parties, right? So we are right? There is a mechanism of prosumption. We are producers and consumers at the same time of communication content. So surveillance mechanisms in corporate social networks are technical choice that engenders control, exploitation, and profit. So we have a control mechanism because of data collection. We have exploitation mechanisms because we work for them, but we don't have a salary, we don't have payment for that, for our data, and a profit mechanism, because these companies, they oriented the technological developments not for human-oriented objectives, but for profit-oriented objectives, and only profit-oriented objectives in some sort of in some companies. So artificial intelligence and machine bias. We have an increasing usage of business intelligence mechanisms for decision making. Several works at the other workshops did that, right? What? Oh, okay, nice. I'm getting there. So data defines what we do next. A programmer elaborates questions, and then they create a model. Well, models are opinions embedded in mathematics. This is not me, I'm not saying that. Katie O'Neill is saying this. So it's like, at some point with artificial intelligence, the programmer decides what will I ask? I decide what question will I do to the machine. So it's not a completely automated process. That's when we have to understand which is the part of human bias in the design of machines. So now there is a major issue regarding these communicational platforms. There is the influence in public affairs or because of the usage for political marketing. Before, when it was only corporate marketing, we had this, oh, okay, I'm giving my data, but I'm not so worried about it. But then when you have an interference in public affairs and in political marketing and somewhat of incredible results in elections, well, this became a major issue for public opinion. So I have a brief analysis of two cases. I will refrain from explaining Cambridge Analytica affair, but these two cases, Cambridge Analytica and Movimento Brasil Livre, the usage of corporate social networks for political marketing. Well, Facebook and other social networks, they have this dual behavior. They behave as computational devices, computational platforms. That is, in this scheme, you have at one, Facebook is functioning as a data provider. Okay. Facebook's functioning as a data provider. So Facebook provides data for the app. This is your digital life that makes. Oh, I'm sorry, I forgot to translate that. That makes profile researching, and then Cambridge Analytica use this data and this profiling to predict preferences, political preference, and then in a fourth level, Trump's campaign staff creates content and predicts how to better distribute this content in order to convince people to vote. And then users again share, debate, interact, and then more data is provided, and then this cycle continues. It's an infinite loop of data circulation. And then in the second, the second characteristic of these platforms, I'm using Facebook as an example because of the many examples we had this last year. But it can be said for all advertisement-oriented companies and social platforms. What's the behavior? Well, at the first level, we have Movimento Brasil Livre. Movimento Brasil Livre is a political movement in Brazil, a right-wing one, and they are famous, regardless of your political position, they are famous for spreading fake news. And then what did they say? Did they do in Brazil? They hired a company named Voxer, and this company, because of Facebook had restricted the rules for spreading news, they were prioritizing individual posts and not page posts anymore. What MBL had the idea to do? Oh, they hired this company Voxer, and Voxer had this mechanism in Facebook that they asked the followers of MBL to post as them in their timelines. So you would circumvent this mechanism, this new rule of Facebook. This was going on for like a week, a month. It was a short period of time because it was pretty immediately after Cambridge Analytica affair. So Facebook was really aware of this stuff, and it was it had some repercussion, but mainly in Brazil. But in this scheme, that is a little bit scary. MBL was the news-making actor, and then they fabricated the news, created content for Voxer platform. They try to publish through user's profile, and then the user that was an MBL follower, they acted as an emitter of the message, and then this user used Facebook as a platform, as a publishing tool, right? And through Facebook, other users that could be friends or friends of friends, and we know how it works, receives the message and then can share, can comment, can interact with the message. So this does not apply anymore because Facebook cutted the. Okay, I'm going to finish. But these are examples of some issues regarding social network platforms, corporate social network platforms that based their business model in collecting data. Why is this problematic in our society? One, we have economic issues that data is collected without the full knowledge of the user regarding what is done with this data, and only for market ends. Communicational issues, because fake news spread is a new issue, and we have no mechanisms to control that, to understand that better. And political issues, because we have opaque ideological influence through these platforms because it's like a black box, right? These algorithms are industrial secrets. And idea censorship, because through these platforms, this is possible also. So for us, these platforms are using AI, are using artificial intelligence, not in a way that privacy is maintained, but as platforms where control is the main rule, where they have control by design environment. Okay, thank you. No, I don't think so. I agree with you because, well, what I think of Google services, for example, there is an interesting application of Google data to health research, right? There are good uses of artificial intelligence. What I understand is problematic is a business model. When you talk about communications and democracy, let's talk about television. All people, mainly in Latin America, we are really pissed that only 6 or 7 families in Brazil, for example, have the right to publish, to create content for television television broadcasting. Like there is Globo, SBT, that broadcasts telenovelas in Brazil. So we have like 5, 6 families, and then when internet came, we are like, oh, we want to share content, we want to use these tools. But if you have like Facebook, Google, Amazon, and Microsoft, and I don't know, 5 companies providing all the services that the major population uses, it's problematic because you have the possibility of having 10, 15, 20 logins, but you are centering all of your communications in closed platforms. And for example, anonymity platforms are criminalized. And why? Because, well, if you center your communications in disclosed platforms that disclose your identity, you are putting at risk sensible data that you don't even know that you are sharing. Several friends of mine had this position, no, I'm okay that Google has my data, that Facebook has my data, until that Jair Bolsonaro was elected, until many Americans had this feeling about Donald Trump election, mainly. But what I'm trying to address is there is a problem when you have centered communications, when you have one tool that has 2 billion users, and these users don't have any idea of how they could communicate without them, you know?
Okay, we have another question.
So my question to you is, what is your focus? The focus is on, one focus could be on power, right? To say, this is a platform, it's too big. If there were a few, I wouldn't care.
Yeah.
Or is the focus is on the technology? AI is a problem, even if it is being used by a small app, right? Or by a hospital, or by the government. And by the way, when you think, you know, I'm interested in your ideas about government versus these platforms. Would that be more legitimate in your opinion if the tax authorities use the same technology, or if the government is using the same technology? So is the problem about the data, is the problem about the algorithm or the use of AI, or the problem about the platform? This is first. Another question is whether you have any empirical data on this use. If you run any experiments, or you collected any data, or anyone else in Brazil on the recent elections, what do you describe to us? Is there any more than journalistic?
Yeah. We are currently working on a research. We collected data about. We collected Twitter and Facebook comments about every candidate in Brazilian election. So we are trying to finish a data analysis about it. And regarding your first question. The problem for me is power relations, because artificial intelligence obviously has remarkable applications for our everyday life. But for me, the problem is power relations when you talk about a monopoly or an oligopoly of the tool development of communication platforms, because communication is such an important thing for us, and it's really problematic when you think no one wants that their mailbox is opened for your neighbor, but everyone is really okay that something that is really more invasive than the openness of a correspondence of a letter to be done for these huge companies that we don't know if we want to trust. You know, there are some services that are nice, that are important for us, that facilitate our lives. But the main issue for me is power struggle between.
I also want to say that we have now some room, a little bit more for some questions also to the other presenters. We have 10 minutes, so I'm going to source a couple of questions. It'd be nice if you would get out from the
Eu não sei como é que vai ser mais fácil.
No more questions, which is possible.
I had
You had a question.
well, I had the comment. Well, and a question.
Nice.
Well, basically a question. Oh yeah.
Do you want to use?
I mean, it's fine.
Okay.
Just tell your question and then we can do them both. If you had a question to her as well.
I have two questions. One, from the last presenter, one for Luisa, but they are strictly connected. Because, thank you for your presentation. It was very interesting. It was strictly connected to the topic of Luisa. So a brief comment, and then I move on to the questions. I think human beings are network profilers because they base their own decision.
I don't think that if we've been paid, it would be okay. I only think that this is an issue that no one is addressing, and it's worth it to explore. But I don't think that it's okay. It's only a component of this ecosystem that this business model structures. You know, what?
I don't think it matters.
Oh, okay.
It shouldn't be part of the argument, in my opinion, because it doesn't matter that we're producing the data without getting paid. It's matter what matters is what's being done with it.
Yeah,
but
yeah,
that's like
yeah. Sorry, before I pass to Luisa, I didn't understand quite your question. Could you repeat it for me, please? No, it's you can repeat because I lost something. Actually, no. It's about preserving your right of being in opposition in your authoritarian government, for example. I think the issue is privacy is a major issue, because when you talk about authoritarian regimes, for example, you don't have the right to express yourself. So if there is a platform that automatically associates your login with your online identity, with your real identity, with your physical identity, that is your address, blah blah blah, you have a powerful tool of surveillance and of repression. You know, this is the point for me, where anonymity is a issue and privacy must be preserved.
Okay, yeah. Thank you, Elena, for the question. I hope I got it right. Like, if profiling and automated decision making then leads to bias. Okay, so well, I think we discussed a lot about like bias and profiling, of course, also in this case, in the particular case that I discussed, that might happen. But it is why then maybe the human intervention it matters a lot. And in our case, I think what we see with profiling in our environment is that at the end, maybe the decision, like it's you can question it afterwards on a judge, but of course, like it has consequences afterwards. But I don't really know if I got it right. I mean, of course, it can create bias, but yeah, it's also about how it is used afterwards.
My question is for Eduard. So I want to echo Luisa's point about the difference between transparency and fairness, and transparency being a tool. But even I think on transparency's own terms, your work, which is really important, is missing, I think, one component, which is in today's world, in the data economy, you can be fully transparent, but you can still obscure the meaningful details by information overload. And I think you're touching on everything, and this is the only thing that was missing for me. You can have, you know, a privacy policy on 500 pages describing all the data flows, but just by having it so long and so filled with information, people will, this transparency leads to meaningless.
Sure, thank you. I
can answer, don't worry. We're already entering coffee break, so people can come in, which is fine, but just so you know.
Well, no, just like to say that we wanted to address this with the seeing over understanding. That's maybe we did not mention like what you are saying precisely, but that was the idea, that somehow the idea of transparency is like, oh yeah, like look at this, I'm doing this, and then like and then actually like you can actually like overload, as you say. I totally agree. Yes.
Who is your question to?
all of them.
Okay.
Okay, just as you know, intuitive kind of thing. This is everybody get up, everybody sit down. And then I do have a comment on a little bit about transparency. Okay, because yesterday I had the good fortune of celebrating my 16th wedding anniversary with my wife, who also happens to be my best friend. Okay.
Congratulations again.
Thank you, or congratulations to her. I'm just lucky. But the point is that we have, I would say, extreme transparency between ourselves in our relationship. But that doesn't always, even in a two-person relationship, we fail all the time. Well, mostly I fail, she's correct, but the point is that it's very difficult. So I'm not saying the overload, also simplifying things. And I work for a company that generates about 75 billion euros in revenue a year. Getting simple things right is excruciatingly difficult. So your point is valid, but even taking the simple steps about transparency, where Edward is going, I would not necessarily say that's not the right way to go, because explainability or privacy or other things are inherently difficult for us.
No, I think that, so I
Yeah, we
was
can take this.
misunderstood.
Sorry,
I just think
we
that it's a different angle to
There are
what he was
more-
saying. It's so comprehensive that I don't want him to miss that.
We don't, the problem is we don't even know what data we have. And
Thank
our
you.
company does, but I would like their answer.
Yeah,
Which one
I will
should we
make them answer. Thank you for your being so transparent about your life. 1 minute each. Go for it.
Sorry, just that it was like closer, like the mic.
Yes, thank you for the question. So I would definitely put forward fairness, but in the sense that also to add that it depends on what are the actors involved, what are the parties involved, because I would only put forward fairness if trust is also implied. And when this is broken, then we cannot even trust on the fairness of the system. So that causes other problems. Yeah.
I think maybe all these issues are like a chain, you know. One cannot be resolved without the other being resolved. So it seems to me that the major discussion is about technology neutrality and the place technology in comparison to humans in our society from now on. I think these issues kind of enclosure. I don't think there is a higher or lower priority, but I think they all have a key factor, that is the relation between technology, human, and nature, and if neutrality is an issue or neutrality is not an issue. So.
Thank you. I have to agree with Alexandra. Both working on blockchain, trust is a big thing for us. Yeah, so yeah, I would agree with fairness. I would go for fairness, but together with trust.
I just say in general, have you seen the Italian movie Perfetti Sconosciuti or Perfect as Strangers? It's very good. Like just like a quick, like it does not go like this in my minute. Sorry, it's just that in that movie they show like that group of friends actually like decide to say like, oh, let's read all the messages that are just like popping up in our messages because we need to be transparent, you know. And the movie actually shows like how much privacy we want, right? Even if in a close relationship. So taking that, I like that movie very much. These Italians, you know. I would say I'm totally biased with Italy. My value is privacy, not data protection, not privacy. Privacy in a very big. I think that transparency is a little bit, data protection is a little bit. I think the privacy in general, that's what I would say. If I could concretize that, I would say like the translational problem is what worries me most. Like how can we transform this privacy into, because like we see, no, like with Helen, no, context is important. In our research, in my research, like embodiment of robot technology is important, like different technologies are different. So I think that the translational problem is a really big issue, but always without the big privacy thing.
So I'm talking about privacy, but I think that eventually, in the end of the day, the real problem is the power dynamic, and it's in specific context of the workplace. I'm talking about the control and dependency of the employee to their employer, what is the right persons? I don't know, but you understand what I'm saying? The technology is enabling today in the internet age.